Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. So today's topic for discussion is very interesting. It is on the Epidemic Diseases Act of 1897. Now, before we get down to the provisions of the act, it is very important to understand the difference between an epidemic and a pandemic. So according to the Center for Disease Control and Prevention, which is CDC, the difference between an epidemic and a pandemic is that an epidemic is a sudden outbreak of a disease in a particular area, in a certain geographical area, while a pandemic is an outbreak of disease that spreads across several countries or even continents for that matter. So COVID-19 is a pandemic and not an epidemic. Now, to talk about the Epidemic Act of 1897, it was enacted way back by the British Parliament with the objective of curbing of the bubonic plague, which had penetrated the then Bombay presidency, which is now presently Gujarat. And it is interesting to note that it's a 123-year-old legislation. Yeah, that's right. It's 123-year-old legislation. This Epidemic Disease Act of 1897 is, and the constitutionality was obviously challenged before the Honorable Supreme Court of India, but ultimately it was remanded back to the High Court. Now, we need to understand one thing: is an amendment essential? Or two, striking down of the act is the need of the hour. Because there's one important thing to note here, that the word epidemic is not defined anywhere. Forget what a pandemic means. So has it lost its effectiveness, its relevancy in the modern world, or is it open to misuse and constant criticism? The real motive of the British, was it to misuse or to arrest or to confine those public gatherings that were led by these freedom fighters? Because ultimately the objective of this act was more to do with prevention of the spread of the disease and not to eradicate it. Our vaccination or drugs regulation, is the act silent on that, which is very important and essential feature of any of the legislations? So to elaborate further on this very interesting and a very important topic, especially in the pandemic world that we're living in, we have with us Mr. Darsh Pareek, a very dynamic, promising young lawyer, and he's currently working as an assistant government counsel come assistant advocate to Advocate General Mr. M.S. Singhvi sir, who's a senior advocate and advocate general for the state of Rajasthan. And just to give you all a brief background about our amicus for today's session, Mr. Darsh Pareek is an advocate practicing before Honorable Rajasthan High Court since 2015. He has appeared regularly before Honorable Rajasthan High Court at Jaipur District and Sessions Court. He has done drafting and he's appeared before Central Administrative Tribunal, Jaipur, Rajasthan Civil Services Appellate Tribunal, Jaipur. He's also worked and specialized in indirect taxation matters related to advisory to startups, companies before arbitral tribunals. And he's also had frequent appearances before RERA, which is Real Estate Regulatory Authority, where he has advised builders and companies on matters relating to Real Estate Regulation Development Act of 16. Prior to working as in the capacity of assistant government counsel, he was independent practitioner, and prior to that, he worked as an associate advocate in the esteemed chambers of Honorable Justice Ashok Kumar Gaur, who was the then senior advocate at that time, when he studied law from Seedling School of Law and Governance, Jaipur National Law University, way back in 2015. So thank you so much, Mr. Darsh Pareek. Sorry we ruined your weekend, we ruined your Saturday morning, but
No, absolutely not. It's my privilege to be here.
So nice of you to say that. And any introductory remarks before we start our segment?
Sure. Like in today's session, we'll discuss about the Epidemic Disease Act 1897, which you said, which is 123 years old. We'll discuss about what are the flaws and what can be done to cure it. So let's start the session.
Please go ahead, Mr. Pareek. Please go ahead. Thank you.
Yes. Like in India's central government and state government, which are empowered to regulate the health-related matters, the Epidemic Disease Act 1897 is the only, or I can say the main legislative framework at the central level for prevention and spread of dangerous epidemic diseases. The act is empowered the central government to take necessary measures to deal with dangerous epidemic diseases at ports of entry and exit at that time. The act also empowers the state to take special measures or promulgate regulations to deal with epidemic within their jurisdiction also. In such emergencies like today's time, the state delegates some of their powers to deputy commissioner in the district. The hierarchy goes on, and health, municipal corporations, so and so. Now, before moving further to the act, I just want to start with the health and relation with the Constitution of India. Understand the different. We need to understand what is major criteria and what the Constitution says about our public health. Like in Article 21 of the Constitution of India, which guarantees fundamental right to life and personal liberty. Life and personal liberty includes both freedom and entitlement. And by freedom, I mean the right to control one's health and body. And entitlement includes the right to a system of health protection that gives everyone an equal opportunity to enjoy the highest attainable level of health. Similarly, with Directive Principle Article 38, 39, 42, 43, and 47, that also put obligation on state in order to ensure the effective realization of right to health. Now, in way back in 1996, Supreme Court in Paschim Bengal, Khet Mazdoor Samiti, which is cited in 1996 4 SCC, page 37, wherein it was held that a welfare state primary duty of the government is to secure the welfare of the people. Moreover, it is the obligation of the government to provide the adequate medical facility for its people. In another judgment, it is a landmark judgment of Paramanand Khatara versus Union of India, which is cited in 1989, 4 SCC, page 286, where Supreme Court held that every doctor, whether at government hospital, otherwise, has the professional obligation to extend his services with due expertise for protecting life. Protecting life is also include protecting our health. Now, I'm regularly saying that there is there is fundamental right in Article 21, also under directive principles. So there is a certain relation between state and center too. Now, this aspect must also be considered as the most crucial aspect in any discussion of the political or social economy of health, since the different public authorities, the union, the central government, and the state government derives their power and functions from the constitutional provisions, which has been stated here, defining and regulating these relations. First and foremost, we must focus on the distribution of power as listed in the Constitution. You all know there are three lists in the Constitution: first list, second list, third list. List consists first list of union, which includes the exclusive concern of the union government. Second concerns is with the state government, and third is the concurrent. So the concurrent is when there is conflict between union and state, then third list comes into action. Further, the residual power, that is those not specifically figured in any of these three lists, automatically belongs to the union. So basically, they both have the power equally. Now, coming on to the list, out of 97 items in list 1 of the Union of India, only item number 84 has some relevance to the health domain. Other than that, no particular item says so or there is any connection to the health. It basically refers to the duty of exercise on medicinal preparations containing alcohol or opium, Indian hemp, and other narcotic drugs, but it does not specifically say so about the public health. However, in item 6, the state list, that is list 2, assign ambiguously the public health, sanitation, hospitals, and dispensaries to the state jurisdiction. Thus, we can clearly say there is no question that constitutionally health is an exclusive concern of the state. But possessing jurisdiction is over items is not the same thing as possessing the financial and political power to make goods that jurisdiction in practice. In fact, the crux of the issue is that inadequacy of resources on the part of the state to carry are effectively their policy commitment and programmatic commitments in the in the domain of health. Just as the state depends on the union for various type of grants and loans to implement its health policies and programs, the local, rural, and urban government seems to be no less dependent on the state government. The same as hierarchy goes on. This has led to policy formation, policy implementation gap that makes the function of specific public authorities or governmental system subsystem in the domain of the public health problematics, if not chaotic and unrealistic. Naturally, the union government, which funds the health program, will find it difficult to resist the temptation to impose its will on state government against their will. There is always conflict between center and state. We all know that. And well, without further going into that topic, we go into our own topic, is the Public Health and Indian Epidemic Act. Now, India is a union of 28 states and 8 union territories. With the constitutional division of legislative responsibilities, central government and the state, both the central government and the state government are constitutionally empowered to legislate on matters of public health. State law may provide for matters relating to public health, sanitization, hospital, and dispensaries, as mentioned in item 6 of list 2. The central government and the state law may also provide for prevention of the transmission from one state to another of infectious or contagious disease, just like COVID-19, or pest infected human, animals, in fact, plants also. There are several central laws managing the prevention of such contagious disease. Now, the foremost is the epidemic disease itself, the Epidemic Disease Act 1897, and another which came in 2005, the Disaster Management Act 2005, basically dominates the legal framework on the public health emergencies. Now, when analyzed the duty power restraint framework, the Epidemic Disease Act only confers the power without creating obligations or accountability or imposing restrictions on government. Are largely replicated in state regulations issued under the act during the COVID times, and which are being seen nowadays. Secondly, the Disaster Management Act 2005, it provides for the government powers in to manage disasters, but it is not a public health emergencies or a focused law. Therefore, it does not provide for the public health emergency or preparedness and responsive measures. Apart from these two, there is International Health Regulation 2005, and in recent, which is the amendment to the Epidemic Disease Act itself, the Epidemic Disease Amendment Act 2020, which came into the force, though it does not say much, or it does not amend much, which is already there in Epidemic Disease Act 1897. The past legislative proposal relevant to public health emergencies range from a targeted public health emergencies laws to a general rights-based legislation and a comprehensive state law on public health. Of these, the central public health emergencies specific bill is extremely limited in scope, that it only deals with the power component of the duty power restraint, nothing else. Other than that, there are state laws also. In order to prevent the outbreak of epidemic, states have enacted their own laws in their territories to curb the outbreak. Obviously, as per the need of the hour, they have to. And what constitution say also, the state have the only concern on state is the uh, have exclusive concern regarding the public health or sanitization. If we let's move further now, coming to the epidemic act itself, which is our topic for today. Since you have given the backdrop, Jay, not more, but still I'll give little much.
Yeah, please.
Uh, Around September 1980, 1896, there is one case of bubonic plague, which was detected in Bombay Presidency, the Mandvi area, basically, now in Gujarat. One of the It was one of the most densely populated area to the rapid growth of commerce at that time, and the plague epidemic spread rapidly due to the constant inflow of the population. It That there are almost 1900 cases reported back at that time per week during the spread of epidemic, which was a major concern. I must say, the India then under the rule of Queen and the British Parliament had no other option but to act swiftly to prevent the plague from spreading to rest of India. It was then the Epidemic Act 1897, which was enacted by British Parliament to curb in the spread of plague. However, it was regarding the plague at that time. Now more diseases have come, and it is the requirement that we must move further. If we move to the special provision of that Epidemic Act 1897, which came at that time, that act consists of 4 sections, which are amended time to time and then when required. The significant provision of the act, which are section 2 of the act, which provides the special provisions for regulation to impose by the government at the time of any dangerous epidemic disease. This provision gives power to the state government if it is satisfied that any part of the state is affected by or threatened to be affected by outbreak of any dangerous epidemic diseases, and if government feels that there are no measures in the ordinary provisions of the law to deal with the said epidemic, the state government may take following measures for the safeguard of the public at large, which shall be temporary in nature, in order to prevent the outbreak of such disease. If I talk about Rajasthan, Rajasthan has recently come on the Rajasthan Epidemic Ordinance Bill 2020, which is now Act itself. Now, Section 2A, moving further, which empowers central government to inspect ships and vessels leaving or arriving in the territories of India, and also empowers the government to detain such vessels if required. At that time, ships and vessels were the native transport. It was majorly used for transportation. The flights came later on. Now that should also includes flights, but it does not. Now, Section 3 provides with the penalties of disobeying the regulations made by the government under Section 2 and 2A. The punishment of such disobedience shall be same as Section 188 of IPC. Now, Section 188 of IPC provides minimum punishment of 1 month and maximum of 6 months, or fine of 1,000 shall be meted out to the person who is in violation of these regulations or notifications of the government. Further, Section 4 provides or protects the government and its employee and officers from any prosecution, civil or criminal, for doing anything in good faith. Obviously, that must be, we are seeing nowadays that doctors are being attacked for no reason. They are protecting our health, but still they are being attacked. is a very shameful act, and can't say more to it. Now, if we talk about Section 2, which which gives special provision of a regulation to be imposed by the government at the time of any dangerous epidemic disease. Now, first question comes with that section is whether our fundamental rights will be affected or not. Now, by its very nature, the ambit of Section 2 of Epidemic Disease Act is wide enough to allow a state or a lower functionary in the administration in dealing with any emergency caused by the outbreak of dangerous disease or require the cooperation of public or corporate bodies in public or private sectors. If the desired cooperation is not forthcoming, a regulation may be imposed. And failure to obey or comply with restrictions imposed by such regulations constitute a punishable violations. Now, power of segregation or quarantine that the central government and state government enjoy may impinge on the fundamental rights as guaranteed by the Constitution of India. It are justifiable. And the judiciary does not shy away from enforcing these rights or voiding the orders that constitute violation of such rights. Now, quarantine, if I say quarantine is a measure that adversely affect the fundamental right to move freely throughout the territory of India. However, this right is to be enjoyed subject to the reasonable restriction that the state may impose in the interest, among others, of the general public. As noted above, Section 4 of the Epidemic Disease Act includes the protection clause that gives state immunity such that no suit or other legal proceedings can be brought against any person for anything done in good faith intended to be done under this act. Now, right to privacy. Now, if we talk about quarantine, now the our fundamental right to move freely throughout the territory of countries already been affected, which also affect our right to privacy. Right to privacy is such, and I can say it is not an absolute fundamental right in India. Even the Supreme Court of India in recent Puttaswamy's case cited in 2017 10 SCC page 1, where the Supreme Court has stated that the right of privacy is an essential component of right to life, no doubt, but that it is not absolute or may be restricted to prevent crime or disorder or to protect health. I go down to the word health, morals, or the right and freedom of others. Because if we talk about the epidemic or if we talk about pandemic, since you have already explained what is epidemic and what is pandemic, now if we talk about both of them, it is necessary to curb or to restrict the movement so that such should not spread in order to protect the health or the right or freedom of others also, because if we are being infected, our right and freedom of others are also being affected. Now, if we talk about the limitation of the act as of today, as in daily cases of COVID-19, we are saying in India have proved all the expected rates of decline wrong. Especially the second wave, it was so deadly. We all know that. We have seen people running head to toe for simple general medicine. The government continue and still the government continues to rely on the 123-year-old Epidemic Disease Act 97 and try to bring some semblance of control to the situation. The Supreme Court, in a decision dated 17th November 2020, refused to even adjudicate on the constitutional validity of the act and remanded the matter to the High Court. And the Supreme Court does not seem it does not seem that think so that such 123-year-old Epidemic Disease Act should be amended or required to be adjudicated as a matter of time, and still remanded the matter to High Court. Now, looking into the present scenario, has refueled the question on the legitimacy and effectiveness of this British era legislation, which may be deemed as archaic in the present scenario, or I can say in a layman's language, or in author's opinion, I would say there is a drastic need over how this legislation, according to the needs and technological capabilities of modern India. An amendment is essential, if not a complete write down of the act, but yes, amendment is essential. The act, divided into 4 sections, is envisaged to the government govern the country during the large scale breakouts like pandemic we are facing today. Yet yet this act possesses some fundamental flaws. Now, if I talk about the fundamental flaws of this act, now, firstly and most glaring or most glaring omission in the act is that the term epidemic has not been defined in the entire act. This leads to an inherent lack of clarity and objectivity, being misused by the government in the situation that it deems fit. Now, in fact, the act empowers the government with certain special powers, but to lack of definition, there is no obligation on them to impose it within a reasonable time. What is an epidemic? What is pandemic? Nowhere defined. It is foremost fundamental flaw in the act itself. And move further. Secondly, punishment. If we talk about section 188 of IPC, this section is a broad provision that deals with disobedience of any order issued by a public servant in general. There is lack of efficient enforcement provisions that are focused on and suit the need of the act. Instead, it relies on general disobedience statutes. Further, the section mandates either 6 months imprisonment or 1,000 rupees fine. Enough. Minimum sentencing may hardly prove as any effective deterrence during the pandemic. Pandemic is such which is affecting globally, and we cannot do anything about it. And if someone is violating any regulation which are being imposed during pandemic, is such punishment is enough? It is hardly a befitting punishment for disobedience that it lies. We talk about COVID-19. One container can spread to the 100 or more than 100 people. Is this punishment enough for that particular person? No. Now it is important to note that Section 270 IPC deals with any malignant action that may spread diseases, inviting 2 years of imprisonment. Section 269 and 271 deals with negligent action which, which can spread or which may spread disease, and disobedience of any, since we are talking about epidemic, so or disobedience of any quarantine or any such rules respectively, both mandating 6 months imprisonment. Now, despite the existence of these provisions, no mention of them in Act. It is only Section 188 on itself. Now, due to this, many state has written orders regarding the COVID-19 pandemic, referring to Section 188. Now, even if I say about Patna High Court, there was one matter, Raj Mangal Ram versus State of Bihar, by making use of Section 188. Patna High Court made that section more stricter and said that mere FIR is not enough, but it must be supplemented with a complaint filed under Section 195 or the CRPC as well. Now, this decision has made the procedural aspect of the punishment under the Act more long drawn, making it clear for alternative remedies as well. But if we say about the stricter action, yes, it is required to take stricter action, because mere 1 month or extending 6 months imprisonment or fine of 1,000, such a petty amount, where in today's time any person can afford. I, my opinion, it's not that something else, so it may not be taken in a wrong sense. Now, thirdly, that this act states that the government may invoke its provisions whenever it is satisfied that ordinarily laws will not suffice. Now, the word satisfied here has an inherent ambiguity. The subjectivity of this term makes it amenable to misuse and wrongful invocation. The Act must deal with the manifest arbitrariness test, which has been held in Shaira Banu's case. The vague and ambiguous scope of the Act, which is vulnerable to be struck down as arbitrary and disproportionate under Article 14 of the Indian Constitution. It is need of the hour. Fourthly, Act completely to address or issue which are vital to the 21st century. We are living in 21st century and we are talking about 123-year-old Act. The Act itself refers to only land and sea routes, which I talked earlier also. There is no mention of air travel. Obviously, since it was implemented at a time when air travel was barely active or not at all active in major part of the country, the Act completely omits the reference to disease management during air transport. time aerial transport, if I say, is more than the sea routes. And I think all must agree with me regarding that land, sea, and air routes, all three should be included. But no, the air route or aerial transport has been omitted, and there is no mention in the act. It is the most essential problem that need attention in the present time, but no heed has been given yet. It also ignores the implementation of large vaccine drives. Now, our Prime Minister said that they'll provide free vaccines, but where are the vaccines? Every state is facing problems regarding vaccines. Since there are no vaccines, how people can be vaccinated? So the concept of vaccination, while quite nascent in 97, has assumed a platform of global importance that mm, definitely requires a mention in the act. Now, fifthly, in continuation to this large vaccine drive, the act is also silent on the part how the vaccines and drugs can be distributed by the government. Without vaccine and the medicinal drugs or the medicinal equipments or medicines, how can one how can one person to be treated? It is foremost thing which has to be decided that how the vaccine and drugs are to be distributed by the government, since government, as per item 6, which I said earlier, and under list 2 of Constitution of India, state government has power, all the powers regarding vaccination and drugs also, and their distribution, but still the act is silent on the part. And talk about COVID-19, that comes under the Epidemic Disease Act, which is crucial of the hour, which are being used worldwide, and that's why we can say court has to interfere in all the matters. Why Supreme Court need to interfere? They are interfering regarding migration of labors, vaccinations, drugs, then supplies, kits, and other necessities or basic requirements at the time of COVID. What are doing so? Even high courts are too active in their respective states. But the government, after all, government is the law-making authority. Courts are not the law-making authority. Courts have only power regarding judicial review, nothing else. But still, court are working and court are giving judgments and taking suo motu cognizance on such issues. Why? Because Act is silent on all these aspects. It clearly demonstrates the gaping holes in the Act. There is no ground for the public at large to hold the government responsible for any kind of negligence on the part of government, the court of law, as there is no proper mechanism on which the government can act on. Government is relying on the 123-year-old Act. Still, there is no proper mechanism on which they can act. The provisions which give the liberty to the state government to prescribe temporary regulations can be more of a trial and error rather than being rigorous measures to control the epidemic. Epidemic is such that need to be curbed at once. Obviously, it is not a thing by just clicking or clapping off our hands, but still, government should take actions and such rigorous measures control the epidemic. But no, we are relying on such British era rules or British era laws. Now, this apart from these, this act can, I can say, can be also be weaponized to violate the right of an individual. Now, taking example, recent the Arogya Setu app. The Arogya Setu app of Indian government traces and monitors individuals who may have COVID-19. Now, the government has contended that this app is a necessary and reasonable restriction on the right to privacy, as it is needed to control the pandemic, while the critics have expressed their concern over its possible use for surveillance. Yes, I have also stated that right to privacy is not an absolute fundamental right, but yes, uh, this this app, since we are taking example of it, and of grave concern. It is not just regarding the epidemic, just in quarantining or in the particular spreading of epidemic, the right to privacy can be harmed, no doubt about it, and we should not get into it. But by coming with such apps which are not functioned properly, uh, have possible use for further other your identity can be used for further things. We may know, we may don't know. And issues like this must be addressed by the act. Why Arogya Setu app was why Arogya Setu app came into existence? If things have been more clearer in the act, of which app of no necessity. But now we are being forced wherever we go that you must have Arogya Setu app, and we don't know how reliable app is. So I'm just it as an example, not my words should not be treated like I'm criticizing anything. But yes, it need to be addressed. The need for an overhaul of the act have more pressing. The recent epidemic disease ordinance 2020 has made or made amendment regarding violence towards the healthcare workers as punishable offense by 7 years of imprisonment. But this is only amendment which recently this epidemic disease act. While it is, yes, it is definitely a step in the right direction, but this move is far from sufficient. Now, firstly, the Indian government may take inspiration from the international health regulations issued by WHO itself, which clearly outlines the obligation of the government and possible action that they make to handle the situation. The importance of these regulations cannot be undermined. They bridge the gap between the modern international standards and Indian colonial legislation. Secondly, the government must also endeavor to strictly enforce the National Disaster Management Guidelines, which came in 2007. Guidelines clearly provide an overview of possible legal, financial, and administrative means to control a disaster. If guidelines are carried out in tandem with the Act, it could enable a smoother functioning of health workers. A definitely definitive link created between the act and the guidelines to ensure uniformity and accountability in the workings of the state government. Now, lastly, if I say National Health Bill, which came back in 2009, and later the Public Health Bill of 2017, which clearly gives a definition of epidemic and provides various other health measures. This was a much more comprehensive and modern bill that contained effective means to tackle a 21st century pandemic, or in 21st century pandemic, I mean COVID-19, only we have seen, yet was never implemented and brought into law by the parliament. It is essential that provisions of this bill be incorporated into the Epidemic Disease Act 1997. Cannot come with that bill, at least have the provisions of that bill to be amended in Epidemic Disease Act in 1897. It is interesting here to note that bill has already envisaged SARS as an epidemic prone disease, demonstrating the forethought and relevancy of this bill. And even the bill has increased the punishment of disobedience to 2 years, at 1 month and 6 months, and also increased the fine to 10,000 for first offense and for subsequent 25,000. Yes, that is some punishment. Which would greatly benefit the Epidemic Disease Act 1897. But still, we are here with the 123-year-old Act. Now, in not taking much more time, just concluding our session here, the Epidemic Disease Act 1897, in my view, has lost its effectiveness and relevancy in modern world. And without the necessary changes, it remains an archaic and colonial piece of legislation that is open to misuse and constant criticism. There is a need to strengthen legal framework to prevent and control the entry, spread, and existence of communicable disease in India. The Epidemic Disease Act 1897, so which is more than a century-year old, has major limitations when it comes to tackling the emergencies and re-emergencies of communicable disease. Like we are seeing first wave, second wave, now we are coming with third waves, and future maybe fourth or fifth. As I have read somewhere, in Germany or in other countries, eighth wave is going on. Now, especially in such changing health context, the Epidemic Disease Act must be amended. Now, over the years, many states have formulated their own public health laws, and some have even amended the provisions of their Epidemic Disease Acts. But however, these acts vary in quality and content. Most are just policing acts aiming at controlling the epidemic, but does not or nowhere deals with coordinated and scientific response to prevent or tackle the outbreak. There is difference between controlling and preventing. They're thinking of controlling but not thinking of preventing by the scientific responses. There is a need for integrated, comprehensive, and actionable and relevant legal provision for the control of outbreaks in India. That should be articulated in a rights based, people focused, and public health oriented manner. Now, at a time when global standard for disease control has set an incredibly high threshold, the Indian government need to realize the inadequacy of the current legislation. Now, apart from that, we have already criticized this Epidemic Disease Act 1897, and without taking further more time, I would only said I will only say that this act requires amendment. If struck down, if not struck down not possible, then amendment, yes. But yes, it is need of an hour, it is must. Yeah,
So
over
much
to you.
there. Yes. Thank you so much there, Mr. Darsh Pareek, for an elaborate yet very meaningful and insightful discussion. I must compliment and congratulate you on a brilliant presentation. It is undoubtedly one of the most important topics, one of the most important issues that a speaker has covered so far on the virtual amicus. Because currently we have been penetrated, we are facing the biggest challenge of our lives. It's a not just a national level health crisis, but a global health crisis. Uh, COVID-19 has penetrated, has entered and has entered into families now of our loved ones, of our nearest ones, and I don't know how many waves are going to follow. One important and a very interesting observation that I made was that this act came into force, this legislation came into force at a time when even World Health Organization was non-existent, because World Health Organization was founded in the year 1948, and this legislation is 123 years old. So, well, an unbelievable state of affairs. It's high time when we have a codified law, a central legislation governing and dealing with pandemics and epidemics, how to tackle, what are strategies to frame, for how long will we see state high courts, uh, courts, the Honorable Supreme Court interfering in such matters, and even the state is helpless for that matter, because there's no specific provision that deals with it, on vaccination drives, on strategies, on so many other issues that are so important and essential in dealing with a COVID like crisis situation. So I hope there is a very big lesson that is learned and that is, imbibed by everyone, and hopefully it shall materialize soon. Hopefully all the bills that are pending will be tabled and will be discussed in the parliament, which is the need of the hour. So thank you so much, Mr. Parekh, there, for dealing with one of the most important issues. Thank you so much, everybody. Our email is mentioned on the channel. For any queries, feel free to write to us. We'll be forwarding the same to our keynote speaker, Mr. Darsh Parekh, Micus, for today's session. And you can even write to him directly, whatever works for you, whatever suits you. So thank you so much, Mr. Parekh. Thank you so much, everybody. And it's goodbye for now. Thank you.